Yes.
My Lords, I was going to move on to the implication of terms. As you'll be aware, there's no real issue as to the law about when terms can or should be implied into a contract. It's set out in the case of Ali, as you know, and in my learned friend Skeleton. I don't need to take you to it once again. I do, with respect, emphasise the fact that there is a distinction between necessary and reasonable. The fact that a term might appear to be beneficial to certain classes or individuals isn't the same as meaning that it's necessary. And bearing in mind that there may have been some debate about this, in fairness, I think it would be right to draw attention to the paragraph in Chitty which deals with the question of precision. That's in the authorities bundle at page 329. And it's...
Hold on. Yes?
It's fair to say that a balanced approach has to be taken. The comment there from the authors, where the term sought to be implied as a term in fact or a term in law, it must be capable of being formulated with sufficient clarity and precision. And it not infrequently happens that the court rejects the implication of a term on the ground that the difficulty in identifying the precise scope of the proposed term evidences the fact that it's not a necessary ingredient of the contract. The vaguer the term, the less likely it is to be implied into the contract, but, in fairness to the appellants, the point can't be pushed too far. The lack of precision doesn't necessarily mean that the term is fataled, because it's not unusual to find difficulty interpreting the words of a particular contract. However, we rely upon the last part of that clause. Again, the more likely inference that the court will draw from the inability of the parties to formulate the term with precision is that no term is to be implied into the contract. And we would say that that's common sense, really. The parties need to know where they stand, obviously, because implication of terms is an objective exercise. It is often the case that the parties themselves won't have given thought to the precise circumstances in which the term is being implied. But nevertheless, it is a legal obligation, and here it's being said that this is a fiduciary obligation, and we would submit that in those circumstances the court should be reluctant to impose a term that can't be easily understood, so that the parties know whether they have complied with it or not. Obviously, the factual matrix is relevant to the way in which the term should or should not be implied into the contract. And my learned friend has already taken you to the conditions of the contract and the model memorandum. I do, though, ask you to go back to that document just briefly, because in my submission the terms show that there was a set of responsibilities and limitations, placing obligations on both parties but also limits of liability, and the two should be read together.
Where are we going?
So if we go to the contract itself, as I've said already, it comes into two parts. The first part is the model memorandum at 109. The relevant articles, Article 10 and Article 11. Article 10 sets out the period of liability, but you'll note the last sentence of that. It is also agreed that the same period shall apply in relation to the designer's obligation to maintain professional indemnity insurance in accordance with Clause 9. Similarly, there are parallel obligations and limitations in relation to Article 11. The client and the designer have agreed that the designer's limit of liability and the amount of professional indemnity insurance to be provided in connection with this agreement shall be the amount of ... So those clauses are there to provide protection to both parties, in theory at least, there is to be a limit of liability which matches the scope of the professional indemnity cover provided under the policy. Of course, that doesn't necessarily follow in any given case that the claimants may or may not argue that the limit of liability is unreasonable or shouldn't be enforced. And of course, if it was an obligation arising following the enactment of the Building Safety Act, then the limit of liability wouldn't be applicable in any event. But that was the purpose of the contract. And we would submit that this is also shown by the sections on page 116 and 117, which again should be read together. Section 8 and 116 is the condition of agreement.
Beg your pardon, which page?
Page 116, section 8, sets out the limits of liability in relation to the time limit, and the limit of liability being the amount of the professional indemnity insurance, as well as some additional limits of liability. And then on 117, section 9 that you've already been referred to, and the part that's already been quoted to you, if for whatever reason insurance is no longer available, the design will inform the client in order the parties can discuss the best means of protecting their respective positions in the absence of such insurance. And we would say that that's consistent with the purpose of the contract, which is primarily to provide professional services to the appellant. And that, of course, is the paramount, we would say, purpose of this contract. But in addition, the purpose is to protect both parties going forward, so that if there is a problem, a company can carry on secure in the knowledge that it should have professional indemnity cover which is sufficient to deal with and meet any claim, and the claimants know that that insurance is in place. But we do say that it's important to note that there is no contractual requirement as to the terms of any such cover. There's no obligation to obtain effective insurance. And of course, everybody will know that there are lots of circumstances in which, for whatever reason, the policy or insurers may refuse to respond. For example, a failure to notify. There's no requirement for the claimants to pay any specific sum of money towards the cost of a policy, and the policy is not to be specifically directed towards the project which is the subject of the contract. And of course, the contract doesn't contain any express term as to the payments of the proceeds of the insurance, which is a term that one finds, for example, in lease agreements or construction contracts. And similarly, the contract, of course, doesn't contain any kind of provision for a guarantee or a performance bond, which would be there primarily to provide protection in the event of insolvency. And so we say, against that background, the judge rightly explored the purpose of the insuring obligation in the passages of his judgment to which you have already been referred, and found that it was there to protect both parties and to provide them both with additional comfort. The second element of the factual matrix is, of course, the fact that the company is a member of the British Institute of Interior Design, and they issue a code of conduct to their members. They provide a code of conduct. There's no statutory obligation, there's no regulatory scheme. The BIID is not enforcing any kind of scheme specifically for the protection of clients. There is, as the learned judge noted, a general responsibility to carry appropriate insurance. and it's under a heading, as you've already seen, responsibilities, the institute and the interior design profession. In other words, it's generally a sensible thing to do. We do say that that kind of code, providing for a general obligation to perform in an ethical way, to support the standing of interior designers to obtain insurance, is quite different from the statutory scheme which was the subject of impact solutions. You've already been taken to the case once, and I hopefully can deal with it very briefly. Your bundle is tabbed, and I'm not sure whether it is, it's tab 6, page 141 of the bundle. If I may, I would simply take you to the section which starts at paragraph 16.
Yes.
It makes it clear that this is all to do with the statutory scheme for compulsory insurance. The Law Society is performing a public duty to safeguard the lay public. And the paragraphs that aren't, in fact, I think, highlighted in your copies, paragraphs 11, 12 and 13, set out the relevant rules. There's a scheme of compulsory professional indemnity insurance which Parliament has authorised. The relevant Law Society rules lay down the minimum terms and conditions of professional indemnity insurance for solicitors. And they define the scope of cover. So, there's paragraph 17, the court is talking about Mr Justice Thomas's view in Kumar. Again, one approaches the construction of this sort of professional indemnity policy against the regulatory background which aims to make sure that protection was provided to the clients of solicitors. That is what the regulatory scheme was there for. And so, unsurprisingly, when interpreting the wording of that policy, the court would have regard to the fact that the whole purpose behind the scheme and the policy in particular was to ensure that the clients of solicitors were protected. And that would tend against an interpretation which would remove their protection in a significant number of cases.
I'm not sure where this really takes it, because in this case there's a contractual term which requires the company to obtain insurance.
It just simply requires the company to obtain insurance.
Yes.
It doesn't say anything about the terms, whether there should be a minimum requirement, whether the solicitors, whether the interior designers can or cannot rely upon notification provisions, for example. All of the extra paraphernalia which is added as a restriction in relation to a statutory scheme isn't there.
No, I see that, but
and so all we really say is it doesn't actually take matters a great deal further than the contract. The contract is as you've highlighted, simply says you will maintain insurance. And so we say that the idea that there's some extra paramount purpose brought in pursuant to the decision in Impact Funding Solutions doesn't take matters any further. All you have is the wording of the contract and the framework of the contract in which the negotiation will take place.
What it does show, isn't it, is that the purpose of the insurance is, at least under the contract, it includes being for the benefit of the client, because otherwise why would you have a term at all?
Yes.
Benefit in the colloquial sense, as Mr. Fletcher says.
Absolutely. We don't demur from that. Absolutely. The way in which the case is put, though, is that there's something else that elevates the status of this term, or is somehow specific to interior designers as a result of the code, and we simply say that's not right. that there's nothing to distinguish this case from any other case where the contracting parties have agreed that the party providing the services will maintain insurance. And in a sense, it doesn't take matters much further, save to say, which is obviously the case, that when you're construing a contract, you look at the purpose of the contract as one of the means for identifying the terms of the contract. What we do say, though, is that there's nothing to suggest that the insurance policy should be construed in any way in the light of either the contractual terms or the code, because there's nothing to suggest that the insurers were aware of any of the contractual framework. And in fact, it would be very surprising if they were.
Well, indeed, if I'm right, the insurance policy predated the contract. I mean, our particular iteration of it was post-dated, but it was rolled over from before.
Yes, and the policy that was in force at the time would have been for a subsequent year, and may or may not have been on the same terms. In fact, it looks like it was. For various reasons, we don't have the policy wording and the policy terms in the schedule for the right year. We don't even know when the claim was first notified. Everybody has been proceeding on the basis that the terms were the same throughout. But yes, this was a rolling policy with different policy years and the separate contracts. And as you've seen, the cover is not even simply in respect of professional indemnity. It's a global policy covering employers' liability risks, public liability risks, and professional indemnity. So from the insurer's perspective, the parties in their contemplation would be anybody who might bring a claim against the insured or intimate a claim against the insured in the policy year to which the policy will respond. And that's it. So going back then to whether a term should be implied, the term that's obviously now being contended for doesn't result in a number of the objections that I've identified in my skeleton, because it's been modified, if you like, to meet some of those concerns. The most obvious one was that it seemed inherently improbable that the insured would agree to a term that meant that if their insurer happened to pay out in those circumstances, they would be precluded from defending the claim. But we still say that even in its modified form, there are real problems with an implied term in the way that it's being put forward. Is the company entitled to use that fund to meet collateral costs, which may or may not have been covered under the policy, such as the cost of defending regulatory proceedings arising out of the same claim? What happens if there is more than one claim? How is the insured supposed to deal with the situation where some claims might be in relation to clients who are covered, who had a contract with it, but others are not? What about the necessary costs of preserving the fund until the claimant's claim has been determined? That's been the problem in this case. Liquidators have been appointed, they're under statutory reporting obligations, but the fund is the only source of potential remuneration. The term, which was originally suggested, would apply to a company in good financial health. And so for that reason, it would appear that the appellants suggest that one should introduce an additional requirement that the obligation only applies if the company knows or suspects that it might not be able to meet the claim. That doesn't necessarily meet those objections. It would be perfectly possible to have a company that was in very good financial health, but would know that if the £5 or £10 million claim being advanced against it was a good one, it wouldn't ultimately be able to meet the whole of that claim. Can the company include the payment when working out whether or not it may or may not be able to meet the claim? My learned friend has taken you to the financial documentation in relation to this company. This point was never addressed in the court below. There's no finding about it. But no one has explored whether or not the director thought that the claim against his company was a good one or a bad one. It was being defended. He may have taken the view that £250,000 would have been more than sufficient to pay the claimants, meet their costs, and carry on with his business. The knowledge or suspicion of the company as to whether or not it may or may not be able to meet the claim, is that to be determined objectively or subjectively? Is it the claim as presented or the claim which the company believes it might succeed? The company may not even know at the moment when the money arrives whether or not it will or won't be able to meet the claim. It may not be in a position to make that determination until it's investigated the claim. But on any view, if there is to be a trust imposed, it must be imposed at the moment when the money arrives. So we accept that the term that's now being contended for is less problematic than the one that's previously been advanced. But it is still difficult. And we say that there are real problems arising out of its workability in practice, because the interests of the company in defending the claim are adverse to the interests of the claimants who wish for the fund to be maintained in their interest. And we say that's very problematic. The idea that the trustee holding this fund must act in a way which is for the benefit of and in the interest of the party whose claim he is defending. And that in many ways, I would suggest, is one of the reasons why the court has been reluctant to allow potential beneficiaries or actual beneficiaries to access rights under insurance contracts, and perhaps why the Third Party Rights Against Insurers Acts are drafted as narrowly as they are. Because there is a tension there, a conflict between the director, who may say, I want to go all out to defend this claim, spending as much money as I possibly can to give me the best chance, and the claimants who say, you shouldn't be doing that, my claim is a brilliant one, and you should be paying all the money to me. And standing back from that, is it really possible to say that the parties to that contract, including that director, would have agreed that when put in that position, that is what he should be doing? So we entirely accept that in certain circumstances, in fact, potentially, although we don't know in the circumstances of this case, the term that's being suggested might be beneficial and might be fairer, but that's not the same as to say it's necessary, because the contract is perfectly workable without it. The contract simply says you must maintain insurance. Everybody knows that in certain circumstances that insurance won't hold good, either because the insured has failed to comply with the notification provision, for whatever reason the claim doesn't fall within the scope of cover, in breach of a reasonable precautions clause or whatever, it can happen. But it provides a considerable benefit to both that insurance is in place. And in reality, it just so happens that one of the clauses that insurers include in their contracts is one which can change the balance of fairness in the way that's happened in this case. But that's not a good reason, we would suggest, to imply the kind of term that's being suggested. So moving then to the third question, which is whether or not a trust should be imposed. In essence, our submissions are these, that first, the requirements for a trust are not satisfied. And secondly, that the court should not rush to find the existence of a proprietary interest in circumstances where the party's interests in an insolvency situation are governed by established common law principles, the statutory third-party rights against insurers scheme, and the statutory rules as to distribution of insolvency. We do rely on the case of Harrington, and I apologise for having to take you to it once again. It's the first authority in the bundle. And we say that it remains relevant for this reason. There are three elements, if you like, to my learned friend's submissions. The fact of the relationship between the three parties, insurer, insured and company, a statutory requirement or a code requirement that insurance should be in place, and the implied terms between the parties. I entirely accept that the third of those requirements isn't met in Harrington, and so it's for the court to consider whether or not that third requirement is one which means that the principles in Harrington shouldn't be followed. But in my submission, in order to do that, one should at least have regard to what those principles were. The case, specifically, I refer to the points that you've already referred to, Lord Hamworth, paragraph 113, pointing out that the fact that the payment has been received is to do with the occasion of the loss rather than the cause. And then specifically talking about the fact, which is what's effectively being contended for in this case, that if the money had been paid out and Mr. Chaplin was solvent, then the defendants could have done what they wanted. They could have paid any sum to Mr. Chaplin. The payout of their same own resources. Does the bankruptcy give any fresh right to the creditor to follow through the bankruptcy, the sum which is paid in respect of this loss by the insurance company to the debtors? It seems to me that this cannot be maintained. And that is really the point, that absent the potential third limb of my learned friend's argument, it doesn't work. It is the case that Lord Justice Atkin deals with the same point at page 7 of the bundle, paragraph 118, the part that's highlighted. Again, drawing the distinction between the fact that no trust would arise before an insolvency situation, and again, it seems to me that that's enough to dispose of the case, because I find it impossible to see how a special right arising out of the circumstances which ordinarily occur in cases of solvency, in other words, the matrix is the same, could come into existence merely because the assured happened to be in difficulties or financial weakness, or to become bankrupt, or the company to have a winding up order made against it when the payment is made. And then finally, I highlight, as you may already be aware, paragraph, page 10, the last paragraph of his judgment, or Justice Atkin's judgment, points out that there was a condition of the defendant's licence in that case that he should have taken out a policy against third-party risks in quite a large sum. So that factor was there, and their lordships were aware of it. And then Lord Justice Lawrence, I think this part isn't highlighted for you. A case when stripped of all its fringes amounts simply to this. The appellant claims the benefit of a contract of insurance made between his debtor and an insurance company to which contract he was neither party nor privy. It's not suggested that the benefit of the contract was assigned to the appellant, or that the assured constituted himself a trustee for the benefit of the contract to the appellant. In the absence of any such assignment or trust, I fail to see how the appellant can establish any claim to the money paid under the contract. We do submit really that the question for the court is whether the assured, the company, has constituted itself as a trustee for the benefit of the appellant in respect of the fund. And the points that I've already made in relation to lack of intention, lack of clarity of terms, and lack of certainty of beneficiaries apply equally in this context, and I don't need to repeat them. The case of Cox and Bankside, we would submit, is perhaps the closest that this court will have in terms of dealing with a similar situation. It's in the authorities bundle at tab 4. I've highlighted the head note. The background is that this case arose in the context of the Lloyds litigation. As you may be aware, there were many claims against the defendants, and there was an issue as to how the proceeds of the insurance policies, which everybody knew were not going to be sufficient to cover all of those claims, should be divided up. And essentially, you'll not be surprised to learn that there was an argument about whether the people who got in first got to the money first, or whether there should be some kind of proportionate rateable analysis and so on. And so the factual circumstances don't matter, but what is interesting is the court's reasoning when being asked to consider whether or not certain different scenarios might arise that would affect the way in which the money should be distributed. And the fourth argument that was being put forward in support of a sort of rateable analysis was that there was a trust that was imposed on the money. So I take you first to the head note setting out what was held by the majority of Court of Appeal at number 1. There was no valid basis on which it could be suggested that by their conduct or otherwise, the agents impliedly agreed that the available policy money should be shared proportionally, and there was no business efficacy reason for implying such arrangement. Once the available cover was exhausted, established claims would have to be met from the agent's resources, or the agent concerned would have to go into liquidation. So the question in this case was whether or not it can be an implied term that there was a proportionate arrangement that meant that the policy proceeds should be shared. And it was said this could be derived from the contract between the agents and the claimants.
Sorry, this is where are you reading from?
From the head note, number 1, and then at number 4, the Lordship go on to talk about the 1930 Act and the fact that that doesn't contain any similar scheme. Number 4, a trust was unnecessary while the insured agent remained solvent, and if the agent was insolvent, the 1930 Act applied. There was nothing in the regulations or the policy or in any document governing the relationship between the agent and his principal that was suggestive of a trust of the policy or of its proceeds. The requisite certainties for the establishment of a trust were not satisfied. And when one follows through the reasoning of their lordships, you can see, I suggest, the same points arising as arise in this case. Turning first to Lord Justice Peter Gibson on page 464, under the heading Trust Fiduciary Obligations. Mr. Martin submitted that the insured agents held the policies as trustees for the names rateably. This he derived primarily from two factors. An agent owes fiduciary obligations to his principal, and an agent is required by Lloyds to effect E&O insurance. He said that the proceeds of the policy had to be held as an incident of the fiduciary relationship between the agent and the principals, and therefore that meant that that duty could only be met by applying the policy monies rateably between all to whom he owed the like fiduciary obligation. Well, Justice Peter Gibson said, "I can't accept this reasoning." He accepted that the insurance was required not just for the insured's benefit, but for the ultimate protection of his principals if the agent becomes insolvent. But it by no means follows that a trust attaches to the policy so affected, or the proceeds of the policy, or if there's no trust, that the agent is under a fiduciary obligation to apply the proceeds of the policy rateably. And then he goes on to point out there's nothing in the regulations that assists, nothing that suggests that the policy proceeds have to be kept separate from other monies held by the agent, which would be necessary if there was a trust. He wasn't persuaded that the requisite certainties that were required, who is the precise range of beneficiaries, what are the extent of their interests, how is the agent supposed to perform their duties of distribution, and so on. Mr. Martin's response was to say that these were practical difficulties, they'd have to be resolved if necessary with the assistance of the court. But the assumption of what has to be proved is not an answer to the question whether the trust is to be inferred, rather the difficulties tend to indicate that the question should be answered in the negative. And later, fourth and fifth, the fact that the Third Party Rights Against Insurance Act 1930 had been enacted didn't help. The fact that there was a requirement under the Lloyds regulations for the agent to take out E&O insurance, again, didn't mean that the policy and its proceeds would be subjected to a trust. Lord Justice Saville Mr. Martin also talked about the fact that there was...
What page, please?
Sorry. I don't need to take you to that. Page 466, second column. Again, not happy about writing such an obligation into a contract. Suggested agreement, to my mind, he says, would be, to my mind, retrospectively to write a bargain for the parties which they did not write for themselves, and which fails every test for the implication of contractual rights and obligations. And then on page 468, the paragraph, which passage which is highlighted for you again. The ambit of the suggested trust is left entirely uncertain. As each claim was established, the agent would have to put and keep any insurance proceeds in a separate account. They would presumably have to wait until it was ascertained what share they would receive. In his comment, which we would echo, indeed, was such a suggestion to be made, the results would be likely to drive agents into liquidation, notwithstanding they had insured against the very liabilities in question. In addition, the suggested trust takes no account of the fact there might well be third-party claimants who are not named, but who had rights against the agents covered by the insurance. Quite unclear whether their rights against the agents of the insurance proceeds are to be effective. There seems to be no business for making them wait, but this would, unless they have to, the effect could well be that they would reduce the insurance fund available, notwithstanding that their claims were not the first to be established. And that is a problem. In this case, there is only one claim arising out of this set of circumstances. It doesn't necessarily follow that that will always be the case. It could easily be the case. Take the example, for example, of an accident happening, resulting in property damage and personal injury as a result of a failure on the part of the designer. It's not immediately obvious, I would suggest, that the contracting party who has suffered property damage should have first claim on that fund over the party who has suffered personal injury. But given the terms of the contract, there is only one fund because both claims arise out of the same set of circumstances and would fall within the same limit of indemnity. The considerations regarding implied terms clearly apply here also. And we do say that there is no basis, for the reasons explained in Harrington, for accepting that a trust has arisen unless it's possible to derive the intention to create the trust from the parties to the agreement. My learned friend has alluded to the possibility that the role of the insurers might be relevant, but it's clear, and I've taken you to the correspondence, that the insurers certainly didn't impose any requirements or restrictions on how the money was to be spent. And it certainly can't be inferred that they were passing the money to the insured with any requirement that it should only be spent in a particular way. So we're not in a twin sector type scenario. I would submit that this could only work if it could be said that the intention to create a trust could be derived from the agreement between the parties by way of necessary implication. And we suggest that the learned judge, noting that of course he wasn't concerned with the specific clause that's being put forward now, but the general comments of the learned judge are equally apposite here. There's no express use of the word trust, that's not fatal of course, but there's no intention, we would say, to segregate this money that can be derived from the arrangements between the parties, which were simply to maintain insurance. Secondly, there's no certainty of beneficiaries, which, as their lordships and Cox and Bankside made clear, was an important factor. These are claims-made policies. There can be a number of claims. And thirdly, there are real problems with the precision of the term that's being suggested. The idea that this term comes into effect not on insolvency or even on immediate insolvency is a difficult one. It is, we would submit, subjective and imprecise for the reasons that I've already explained. And we would submit that in those circumstances it would be surprising if the director were keen to take on additional fiduciary obligations which extend well beyond the extra ones which, I don't need to take you to it, but the issue about when directors in any event owe additional responsibilities in the imminent insolvency of their company has been the subject of heated debate and was the subject of the very lengthy decision in the case of Sequana, which I've included in the bundle. It might be possible, I suppose, to say that the term could be implied in a different way, so that the obligation only arose in a Sequana situation. But the reality is that that wouldn't necessarily help the claimants in this case. But to move the date forward to some kind of imprecise date when the director, looking at this fund of £250,000, which has just landed in his bank account, might suspect that that might not be enough. It doesn't work. And we would say that it also doesn't work if he can then spend the money, because there's no certainty as to what the trust property even is. It's an uncertain amount out of an uncertain fund. The trust presumably has to arise only when the director makes the decision at the moment when the money lands in his bank account. But his decision may be very different a few weeks later. But that, I would submit, can't change the situation. You can't have a situation where the trust, where the sum of money isn't imposed with the trust when it arrives in his bank account, but then it is a few weeks later when he suddenly realises that the claim against him is rather bigger than he thought it was.
But there might be problems anyway with an agreement that the rights of the company to receive proceeds under the insurance policy are vested in the company beneficially until such time as the company is or is on the verge of insolvency. Because that sort of creates some British legal problems, doesn't it?
It creates a whole host of problems,
yeah.
and practical issues. And then what happens when the liquidators are appointed? There's no access to the fund then. You can meet the claim, you can defend the claim, but you can't manage the fund. You have to maintain it, you have to comply with your statutory obligations as the liquidator, but you have no money to do it, which is what's happened here. And that brings me to my final point, which is that insofar as there are dicta in these authorities, they are very much against the idea of interfering with the existing scheme that's in place in relation to the priority of creditors and the rights of third parties to interfere with insurance contracts. I confess I haven't attempted to work through what the possible implications might be of the term that's now being put forward. The original term, of course, gave rise to the problem that we see in the underlying particular claim that I referred to at the beginning, which is that the insurance company are being pursued on the basis that they should never have paid the money out to the insured in the first place, and they should have paid it direct to the claimants. The situation is more complicated. Now what's being suggested is more nuanced. But again, it's not difficult to see that there might then be circumstances in which the ultimate beneficiaries may be arguing that because they would have a contingent right or a possible right in the proceeds, the insurer's right to exercise their obligations, their rights under Clause 7, Condition 7, might be hampered in some way. And in my respectful submission, the comments that were being made in the case of Angove really reiterate the general point that we had already advanced. Lord Sumption in that case was essentially saying that quite apart from the specifics of whether or not a constructive trust should be employed on the circumstances of that case, there were fundamental objections to it. Paragraph 25, at the time when the money was paid to by the customers to D&D, it was not impressed with any trust in favour of Angoves. And we would submit that's the same here. What that means is that the customers weren't imposing the money with any trust, in exactly the same way as the insurer is not imposing the money with any trust here. If, therefore, a constructive trust came into being, it did so for the first time upon its reaching the hands of the payee, which is what's being contended for here. It's not being suggested that the insurers held the money on trust, they were entitled to pay it out. What's now being said is that when it was received, it was impressed with a trust. And Lord Sumption goes on to say the money would thereafter be traceable as long as it remains identifiable in the hands of any third party, wouldn't form part of the insolvent estate, thereby conferring priority on Angoves over other creditors, including many whose position would otherwise be no different from theirs. This is elementary and fundamental. The statutory rules of the distribution of insolvent estates represent an important public policy designed to achieve a pro rata distribution of the company's estate between its creditors. And he goes on to talk about the fact that that might act arbitrarily in a particular set of circumstances, and that there were ways in which the cut-off date could be mitigated. It's inherent in the statutory scheme of distribution in insolvency that apparently arbitrary results may follow from the adventitious timing of the commencement of the liquidation, especially in the case of deferred obligations. He talks about the various possibilities. In the nature of things, these consequences involve a detriment for the payer, attributable to the timing of the company's insolvency and the windfall for general creditors. But then goes on to say at paragraph 27, English law is generally adverse to the discretionary adjustment of proprietary rights. And he drew a distinction then by quoting from Lord Brown Wilkinson in the Cedar Capital case, a remedial constructive trust. I'm reading from paragraph 27 on the top of page 3192. A remedial constructive trust, as I understand it, is different. It's a judicial remedy giving rise to enforceable equitable obligation. The extent to which it operates retrospectively to the prejudice of third parties lies in the discretion of the court. And his point, his objection essentially, is that the court should not be accepting that kind of argument, that kind of contention. And so he comes down to paragraphs 29 and 30, the specific requirements that he would expect to see before the constructive trust could be imposed. In other words, the vitiated intention or the fruits of fraud. And that's why he finds that Nestor was not correctly decided. In particular, the prospect of a total failure consideration, however inevitable, is not a circumstance which could have vitiated the intention of the ship owner to part with its entire interest in the money. If an actual total failure of consideration doesn't give rise to a proprietary restitutionary right, I do not see how a prospective one can do so. So again, it's not specifically on the facts of this case, but the general tenor of the observations we would submit is the same. It is right that the Third Party Rights Against Insurers Act doesn't meet every set of circumstances. It's included in the bundle. It makes clear that the rights to a prospective beneficiary only arise in relation to a relevant person, and a relevant person is essentially when the company becomes insolvent. And that does mean that in theory there is a lacuna in circumstances where a payment is made, in circumstances where a company might subsequently become insolvent but has not yet. But that is the statutory scheme, and we would suggest that the court should be reluctant to interfere with that statutory scheme, and indeed the existing rules about the priority of creditors at the behest of a claimant who has entered into a contract requiring the designer to carry out a number of obligations, one of which is to maintain insurance. In other words, what we really say is that it is not enough, if the court is to impose a trust, it's not enough to simply say it will be more just. And really we would suggest that is what the appellants are asking. We don't know in this case whether or not the director in fact has a good claim for £250,000 or not. Because the liquidators haven't been able to spend any money, they haven't even been able to identify whether that's a good claim or a bad claim. In effect, in the way in which the argument is now put, the appellants are not saying you can't touch the money, you can't spend money. All they're saying is a term should be implied giving us precedence over other creditors. And we would suggest that that sort of term should not be permitted. Anything else that I can assist with?
No, thank you very much. Yes, Mr. Fletcher.
My lord, may I have one moment?
Yeah, of course.
So I think it was my Lord Justice Arnold who raised the question whether there might be a case. I think the question was in relation to a fund which was depleted to zero, or was depleting to zero. But it prompted me to think of this related question, which my submission does arise in this case, which is whether you can have a trust with different purposes for the benefit of respectively different beneficiaries. So if I translate that into the facts of our case, what I'm contending for is a purpose trust to give effect to the purposes of the insurance, which include a paramount purpose to secure that a valid claim is paid, but also a purpose for of use as defence costs.
Yes, but it's not just a question of different purposes. The purposes here are antagonistic, as Ms. Chalmers pointed out.
Well, they're antagonistic in the sense that the effect of use for, let's call it, well, the purpose of defence costs will have the effect of eroding the amount available for...
Potentially to zero.
Potentially to zero, I accept that. But in those circumstances, the only protection we as the, in my submission, beneficiary of the purpose in relation to payment of the claim, the only protection we have is the limitation that monies must be used in good faith. So my learned friend said, oh, well, the director may take the view he wants to run up defence costs. Now, if what's being done is running up defence costs in good faith, in bad faith, that would obviously be out with the scope. If it's in good faith, then the beneficiary of the other aspect just has to put up with the fact that there is a legitimate call on the trust assets, which mean that his interest will be reduced. But, my Lord, the same, but in a small...
But what's your answer to the point that it puts the trustee in a position of insoluble conflict?
Well, conflict of interest has to be resolved when it arises in the way that conflicts do. It may involve appointing different people to have different responsibilities. But, my Lord, as I say, that arises in any situation of conflict of interest. One might say the same, supposing a trustee...
I'm sorry, the whole point of trust law is to stop conflicts of interest.
Well,
whereas you're saying we're going to impose a trust which creates a conflict of interest in the trustee.
Well, Lord, you could say the same in relation to a trust which a trustee is administering, but he is entitled to take his own expenses. Now, there's plainly a conflict there between the interest of the trustee, who has an interest in his reasonable, generous, adequate, whatever it is, compensation, and the interest of the beneficiary, who would rather that nothing or as little as possible is spent on costs. That's a conflict which may arise. The law of trust can't dispose of all potential conflicts. You might have the same with a trust which has several beneficiaries, and there'll be it's different. That's not the conflict between the trustee and the beneficiaries. But, my Lord, my submissions on the word by way of preface, if your lordships are interested, of a case which simply makes clear that that was an express trust, that there's no difficulty at all about having different purposes for different beneficiaries. So at least I deal with that point. I accept it doesn't, that point of itself doesn't answer the existence of a conflict case. But I'd say this in response to that point. why should the existence of a possible conflict of interest mean that the preferable solution is to say we're not going to give effect to the purpose at all? We're not going to give any effect to the purpose for which the monies were transferred. So in my submission, the fact of an actual or potential conflict of interest in trust purposes does not mean that that a trust cannot be, is not imposed. The case that I had in mind, would you like me to hand it up to you? Well, I'll tell you then. If your lordship is not concerned with
the basic proposition that an express trust can have different purposes for different classes of beneficiaries doesn't seem to me to be controversial.
Very well. At any rate, the case name, and if anybody subsequently thinks anything will come of it, then it's there. It's Denley's trust deed. It is actually referred to, but with no detail in Twin Sector itself. Decision of Mr. Justice Robert Goff, as he then was. Now, the learned friend, on a couple of occasions, emphasised the point that an implied term must be necessary and not merely reasonable. I completely accept that. But my short answer in this case is, if the result of not imposing, if that's the right word, a trust, is that a core purpose of the contract will be defeated, then it is necessary to impose trust. I beg your pardon. That's a later stage. The implied term I'm talking about. So if the failure to imply the term will lead the predominant purpose of the contract to be frustrated, then it is necessary to imply the term. So far as the sufficient clarity point is concerned, have we formulated the implied term with sufficient clarity? In my respectful submission, we have. It has been objected, oh, well, there could be all sorts of difficulties in its application, but there's no suggestion there's any difficulty in understanding what the term is. In my submission, it is easily understood. The learned friend took you to page 109, which is articles 10 and 11 of the design contract. And she said, pointing at these, well, that shows that the intention was to provide benefit to both parties, citing in particular Article 11, to the effect that the limit of liability and the amount of professional indemnity insurance to be provided are the same. And I quite accept that is a clause inserted for the benefit of the designer. that I quite accept. And indeed, I would say it's completely obvious that a contract of this kind is certainly going to have terms which are introduced for the benefit of one party, another party. But Article 11 imposing a limitation of liability is completely different in its purpose and intent to the term requiring that there shall be an insurance policy. And we are concerned with the question for whose benefit is the, and for what purpose is the requirement for the existence of the insurance policy. And that, in my submission, as the other references I took you to show, clearly the insurance was provided for the benefit of the client. That was its paramount purpose, consistent with the usual rule, my submission, in professional indemnity policies. Yes, my friend made, my submission was a surprising submission that there was no obligation to obtain effective insurance. Now, if by that she simply means no obligation to obtain insurance, which in whatever circumstances may arise will inevitably pay out in respect of claim, well, I accept there's no inevitability in that context. But what the contract required, Lordships will recall, was appropriate insurance. And appropriate must either mean or imply, to the effect that it must be a professional indemnity policy of a type which satisfies the usual requirements of professional indemnity policy in a broad sense. It mustn't be so restricted and inadequate a policy that it is, although called such a policy, isn't what in it. So that, in my short submission, is the answer to the, it doesn't require to be effective, but it does require it to be appropriate. My then friend was good enough to accept that of course, the policy does provide, she said, both with additional comfort. And she's right, but in my submission, once one understands and is reading this against the background, which parties are to be taken to be aware of, that the paramount purpose of indemnity insurance is to secure payment, that the funds will be available to pay valid claims, means that the paramount consideration here in terms of comfort was in favour of the client. I thought I understood my learned friend to say that I was implying that the considerations I'm putting forward to the effect that a policy such as this is to operate for the benefit, for the protection of the insured, was something special to contracts relating to interior design. That's certainly not my intention at all. I don't say there's anything special about interior designing for these purposes. I'd rather put it the other way. There's nothing special about solicitors or lawyers or where does one draw the line? Doctors, engineers, they're all professionals. They're all people on whose part a breach of duty may cause grievous injury to their clients. And that really is the background and the reason why it is said that the paramount purpose of such policies is to secure payment. Sorry, that's much too compressed, not to secure payment, but to secure that they shall have financial resources to meet claims. It's interesting that the word secure is used, but I of course, again accept it's not being used in its technical context, but it is something which, in my submission, does add to the confidence the court may feel that the right response to the existence of such an implied term and such a purpose is to impose a trust. Now, as to, an old friend said, effectively, I think, without conceding the point, that I'd sort of dealt with the question of implication in terms of the design contract by reference to the provisions I've taken you to, but not to the question of implied terms of the insurance contract. Now, it must be notorious in the industry that paramount purpose is solicitors' policies is to pay insured claims. Again, forgive me for the compression. And if I'm right, it's a matter of law. It may not yet have been stated, but it's the same in relation to all policies of this kind. And it's something which arises out of the background. And in my submission, it is an implied term of the insurance contract just as much as it is an implied term of the design contract. And you'll recall that when I was dealing with the interest that the Institute of Interior Designers would have in the policy being used for the benefit of claimants, I drew attention to the fact that it was a selling point not merely for interior designers, but also for the Institute, that the insurance for which they provided was to give effective protection to clients of interior designers. And just in the same way, it's a selling point for insurers that their policies will respond to claims because of clients, because without that, policies will not be attractive. And therefore, it's in the interest of insurers as well that the proceeds of insurance claims are not just to be at the free disposal of any pool of general creditors when paid, but that there is some control over the means or what happens to those means, so that the indemnity insurance does actually have the effect which it's expected to have, intended to have, which is its paramount purpose. Now, there's a kind of passage of my learned friend's submissions which really amount to this. Well, in lots of circumstances, it could be very difficult to deal with the proceeds of an insurance claim if you're right. No, I'm trying to think of a suitable image of this. It's sort of throwing leaves. Nothing as unkind as throwing sand and the dust in the eyes of the observer, but it is, in my submission at heart, an attempt to say, oh well, it's all so difficult, let's forget about the implied term. And my fundamental answer in relation to cases with difficulties, well, yes, sometimes difficult cases do arise. Not particularly so in this case. I accept, and we've been debating, there is the question of conflict in relation to use of monies for defence costs and for payment of claims. But the notion, for example, that in our particular case there could be a multitude of claimants is, in respect, not so. In fact, there is, the court is concerned with, a fairly straightforward situation of one claimant in relation to one policy. As in another context, my submission is you don't throw the baby out with the bathwater. Just because it may be difficult doesn't mean to say, okay, never mind, the creditors can have the lot. Or, beg your pardon, it can all just go into the pot for creditors. I think my learned friend said there's no evidence that the insurers know of the terms of the contract. Lord, with respect, I find that a very surprising, well, an unrealistic suggestion. After all, it would be expected that the presentation of the risk to insurers would include details of the terms on which they do business. And certainly include the fact that they're members of the Institute. And therefore, insurers would certainly view that it was a requirement that the policy was being provided in circumstances where it was required by those terms. And therefore, in my submission, they do know that. They do also, therefore, know, when they look at the general scheme of things, that the purpose of it is to provide protection. And they, in my submission, must be taken to know that the terms of the Institute do have these stipulations that the insured be entitled to inspect the policy, and the reference that I showed your lordships to the obligation in the event of renewal not being available on reasonable terms for the parties to meet to discuss how they shall deal, how they shall protect their position in the absence of insurance. Now those are the critical features which give rise to the implied term that I have contended for in the design contract, and they are all present in to the mind of insurers. And my lord, my learned friend also submitted that the requirements for the imposition of a trust weren't met. Now, in my submission, they are indeed met. There's clear certainty about what is the fund in question. It's the insurance monies themselves. Clarity about what that money can be used for. In essence, the purposes for which it was transferred in circumstances where the relevant state of mind has existed. There's clarity, too, as to the identity of the respective beneficiaries of the two, if you like, interests. Namely, it's the company, Oscaro, which is the beneficiary of the right to use monies in good faith for defence costs. And it's the client who is the beneficiary in respect of the purpose to use the monies for a valid claim. It's the same really in answer to the points my learned friend made in relation to Fox and Bankside. I'll just see if there's something specific I need to say in relation to page 100. I think my submission here is that one must remember that Fox and Bankside, 1995, it predated both Lord Brightman quoted in the impact case, and therefore it's not dealing with a case where there's the paramount purpose of the policy that we are dealing with. I did say to you that there are real problems with the precision with which the term has been drafted as we put it forward. But in my submission, the term is precise, it's clear. I respectfully reject the suggestion that it is not.
Is that the right question, though? Because you may have been able to, let's assume you formulated a term which is precise. The question, isn't it, is whether that is the only term which could fulfil the need that the lacuna, if there is one in the contract, creates. And if there can be a whole variety of things the parties might have agreed, then there's insufficient certainty, isn't there?
Well, I think, let's take it in stages. The submission that or rather the suggestion that the term must not be used for a purpose which conflicts with the paramount purpose. In my submission, the parties must, if the officious bystander had proposed that, have assented to that element of it. And therefore, the only question is whether they would have assented to the formulation reasonable risk that, let's get the exact words, reasonable grounds to believe or suspect that Boscolo might be unable to meet the appellant's claim in due course from other resources. Well, Lord, in my submission, when one thinks about it, that is the correct test. And because nobody wants money to be advanced, if there's a real risk, it won't be used for the paramount purpose. Anything less than that is insufficient. Anything more than that is excessive submission. But again, look, I should be very careful, because if the suggestion is, and I don't know quite how this works in relation to the officious bystander, then actually what you have, if the officious bystander says, what do you do in this situation, and the parties don't agree, well, you do nothing. But both of them are bound to have agreed that to do nothing was unsatisfactory, because it would defeat the purpose of the contract. And therefore, in my submission, the parties also, it's important to recall, we're not dealing with the actual parties, we're dealing with the notional reasonable parties who've got all the relevant background knowledge and so forth, and will respond reasonably. And now I should, well, it was in my skeleton. Your Lordships will recall my references to Lord Staines's article. Would my friend forgive me if I took you to that and of course come back on it? It is you find it in the authorities bundle at page 341. And the passage I like to remind you of is page 343 towards the bottom. And Lord Staines says it's a defensible position for a legal system to give predominance to the subjective intentions of the parties. Can claim to be committed to the ideal of perfect justice. But that is not the English way. Our law is generally based on an objective theory of contract, involves adopting an external standard given life by using the concept of the reasonable man. Commercial advantage is it promotes certainty and predictability in the resolution of contractual disputes. And as a matter of principle, it is not unfair to impute to contracting parties the intention that in the event of a dispute, a neutral judge should decide the case applying an objective standard of reasonableness. That is then the context in which in English law one should interpret the proposition that the effect must be given to the reasonable expectations of honest men. And I just pause to say in my submission that is exactly what implying this term and in due course finding that it was a purpose of trust when money was paid in the relevant circumstances, that it would exactly conform to the reasonable expectations of honest men. And then it goes on, it's possible to refine the meaning of the proposition once one uses external standard of reasonableness. The reference to honest man adds little, hypothetical reasonable man pursues his own commercial interest, he is by definition not dishonest. It can be redefined. So the law must respect the reasonable expectations of the contracting parties. That brings me to consider, the law must respect the reasonable expectations of the contracting parties. That brings me to consider what the reasonable expectations of the parties means. The expectations that will be protected are those that are, in an objective sense, common to both parties. The law is not concerned with subjective expectations of the party, protects only expectations which satisfy an objective criterion of reasonableness. And then, next paragraph, first line, it's of some relevance to consider the status of our proposition. It's not a rule of law. 2 lines down, I prefer to regard it as the central objective of the law of contract. Now, and he goes on and ends the paragraph, the aim of protecting reasonable expectations remains constant. And that, in my submission, is thinking which is relevant when considering the reactions of the reasonable parties when this term is proposed. Now, at one point, I thought from what Melanie was saying she had misunderstood my submission, and I just want to make it absolutely clear. I am not submitting that in circumstances where money is transferred by the insurers, but later the relevant state of mind is formed. I'm not suggesting that an implied trust will arise at that point. I accept and submit time to judge whether there's the relevant state of mind and therefore whether the trust arises is at the time of payment. So when she says that yes. And she made the submission that dicta in, I think, in Sequana, to the effect that, in principle, the law is opposed to the idea of interfering with the priority of creditors, something to that effect. But, my Lord, equally, I certainly don't recall that in that case, or any of them, there was the equivalent of the paramount purpose in play. The law is also concerned with not allowing the statutory pari passu regime to interfere with established rights of parties in circumstances where party A is holding B for some specific purpose for the benefit of another person, and the pari passu regime should not be allowed to ride roughshod over that. My lords, there's plenty of time for further vivas of either of us if the court is so minded, or if there's anything that either of us can assist in or
No, thank you very much indeed. Mr. Fletcher, Mr. Munro, Mr. Chalmers, thank you very much for your respective submissions. We are reserving our judgments They will be provided to you in draft in the usual way and for the usual limited purposes, of which you will be aware and know the cautionary words at the outset. And we would hope that once you've got the judgment, you'll be able to agree outstanding matters, but if not, we will address them on paper. So thank you very much.
Right.